On June 28, 2024, the Supreme Court issued its decision in the companion cases of Loper Bright Enterprises versus Raimondo and Relentless Inc. versus Department of Commerce. The decision overturned the so-called Chevron Doctrine and could have vast implications for health law and policy. I'm Stephen Morrissey, managing editor of the New England Journal of Medicine, and I'm talking with Erin Fuse Brown, a professor of health services, policy, and practice at the Brown University School of Public Health and a member of the journal's Perspective Advisory Board. Professor Fuse Brown has co-authored a perspective article about the Loper Bright decision. Professor Fuse Brown, what is the Chevron Doctrine and why has it been important for government agencies?
The Chevron Doctrine is probably the most famous administrative law case that students of administrative law and law in general study all the time. And the historic Chevron Doctrine was from a case that basically says that the courts, particularly the Supreme Court, but any federal court that's reviewing an agency interpretation of a statute, the statute that the agency has been tasked with implementing, is required to defer to the agency's interpretation of an ambiguous or silent provision of the statute that the agency has been given the authority by Congress to implement. So basically, that's what's known as Chevron deference. It's this posture of judicial deference where an agency is given the first cut at being able to interpret a statute that it has expertise in administering, and then the court will basically not set aside an agency interpretation as long as that interpretation is reasonable.
So, given the recent history and the composition of the court, this decision wasn't entirely unexpected. What were the signs that Chevron was coming under increased scrutiny in the past few years?
So even though the Chevron Doctrine has been in place for 40 years and is considered to be, again, this towering opinion of administrative law, in the last few years, the Supreme Court, particularly under Chief Justice Roberts, has viewed the Chevron Doctrine with increased skepticism and even hostility. So there's this sort of general reluctance to apply Chevron deference that the court has backed away from deferring to agency interpretations. It hasn't invoked Chevron to defer to an agency interpretation in many years. People arguing in front of the court have not used the Chevron Doctrine to defend an agency's interpretation of the statute in several years because, frankly, the court has signaled that it is going to revisit the Chevron Doctrine. So it wasn't a surprise that the court took this case, the twin cases of the Loper Bright and Relentless cases, clearly with the signal that it was planning to revisit and potentially overturn the Chevron Doctrine. And in fact, that's what happened on June 28 of this year.
What were the facts in those two cases, and how did the court justify its decision?
The facts of those cases are sort of a bit, again, specific. It involved fishing boats and the Department of Commerce requiring the fishing vessels to carry along certain folks who were going to sort of look at the fishing practices and pay for the monitors to accompany the fishing vessels on the water when they went out to sea. So this is, again, not something that is particularly a big deal regulation. It doesn't affect anything other than the fishing industry. But basically, the agency, the Department of Commerce, had interpreted a statute quite some time ago that basically said that under its regulation, it had the authority to interpret an ambiguous or silent provision of the statute to require the fishing vessels to pay for these monitors that they were required to take out to sea. So that was the interpretation, and that set up these twin cases that had the same set of facts to go before the Supreme Court, really to ask this question of whether or not courts are going to continue to follow the Chevron Doctrine to defer to agency interpretations of their statutes, or whether courts are free and, frankly, able to replace agency interpretations with what they think is their own best interpretation of the statute.
So you say in your article that in overruling Chevron, the court majority did not specify a replacement or provide a roadmap for lower courts. How will that gap affect reviews of agency decisions going forward?
Even though the court says Chevron is gone, Chevron is overturned, it's overruled, there is no such thing as Chevron deference anymore, the court is going to decide for itself independently what statutes mean, because they say courts are well positioned to read statutory language and come up with the proper meaning of that. There is this sort of signal that in some cases, Congress will signal that it has delegated the authority to the agency to fill in the gaps or to come up with implementing interpretations because Congress cannot legislate in any level of specificity. And the court says when there is such a delegation of authority to the agency, courts might provide that delegation and the agency interpretations with some respect. But it doesn't give us any indication of what the factors would be. It makes reference to old pre-Chevron cases like the Skidmore Doctrine, again, that basically says when we agree with the agency, we'll sort of respect the agency's interpretation. But when we don't agree, or when we don't think the agency's thinking has been thorough or has been consistent, then we're going to overturn it. And the court is not going to hesitate, again, to replace or substitute its judgment for that of the agency. So the court doesn't say this is what's going to take the place of Chevron deference. It just says the courts are the ones who are going to decide. And frankly, the court does say very clearly that even in the cases of technical or scientific statutes, which for health and safety agencies like Health and Human Services, the majority of its authority, they said even for these technical or scientific statutes, there is no such thing as Chevron deference. So the court's not going to take a different rule of thumb for scientific or technical statutes and agency interpretations of them than it does to ordinary statutes that the court says it has the expertise to make the interpretation.
Looking at healthcare, what could increased challenges to government regulations mean for health agencies?
I think that one of the big outcomes for not just the agencies, but for regulated industry in the healthcare space or in all spaces will be this increased challenges to agency rules that rely on interpretations of the statute, which is a lot of rules. And so what this might mean for HHS, CMS, FDA, and all the other health agencies within HHS is that these rules that require the agency to parse technical meanings of scientific terms like what is a protein, or technical terms like how do we calculate the Medicare payment formula, is going to be subject to litigation and second guessing. Any litigant, any plaintiff who disagrees with the agency's interpretation can run to court, challenge the agency's interpretation, and get a second bite from a court that frankly has no training, no expertise in that subject area. And as long as they can make a good enough argument, they could potentially convince a court to adopt the plaintiff's preferred interpretation. So I think that what it does is it opens up a lot of uncertainty and a lot of opportunity for more regulatory challenges, particularly by plaintiffs or industry actors that are disadvantaged by a particular agency interpretation or rule. They're going to have every incentive to litigate that and to see if they can get it overturned. And for the agencies, I think that this puts them into somewhat of a defensive crouch. They know they're going to be slapped with litigation as soon as they come up with any rule. And so I think that's going to chill agency regulatory action. It's going to make it more costly and more time consuming. And also they're going to be a little bit more gun shy to take regulatory postures that they know they're going to be sued over.
In a related perspective article, Engels and colleagues discuss another case that was decided this term, Ohio versus EPA. What could be the implications of that decision for health agencies, and how is it going to interact with the Loper-Bright decision?
The Ohio versus EPA decision was issued around the time of the Loper-Bright decision, and it was one of actually 4 decisions that implicate, quite frankly, an attack on the administrative state or federal agencies by the court that was issued at the end of its 2024 term. So the Ohio versus EPA case basically was a case that was decided, as the Engels perspective points out, from the shadow docket, meaning it wasn't subject to the full briefing and record that normal litigation is subject to, but it did have an opinion. And in that opinion, it basically said that there were certain EPA downstream pollution rules that were invalid or potentially invalid, and they were subject to a pause or a stay, not because they were substantively wrong or not because they relied on an interpretation that wasn't going to be subject to Chevron deference anymore, but rather because the agency failed to adequately and in a detailed way respond to all the comments it received from, in this instance, the states that objected to some of these downstream pollution rules. And so this requirement is basically, in order to make your rulemaking solid and resistant to overturning by federal courts later on, not only do agencies have to make an interpretation that the court will agree with, it also has to respond to every one of the major comments that it receives from all the thousands of commenters that it receives comments from in the notice and comment rulemaking process. And of course, this is just contributing. Agencies have always had this requirement, but in this case, the court said what you did was insufficient. The response was not detailed enough. And so therefore, what the message is to agencies is, again, the rulemaking process, which was designed by Congress to be somewhat nimble, to move faster than legislation, to allow agencies to act, to regulate in the public interest, it's going to be bogged down. It's going to be bogged down because you need to go through each of the thousands of comments, again, with a fine-tooth comb, develop a response to each of those, and also make sure that your record is airtight, that your interpretation is consistent and solid and backed up. And all of that still could be subject to judicial overturn if a plaintiff or a litigant decides to challenge it and the court agrees. So it's all contributing to a chilling effect, to, again, a hostility or skepticism of agency action from this, I think, worldview that the Roberts Court has, that agencies have gotten too powerful, and that Congress has in some ways shirked its duty to legislate with sufficient detail and given over the reins to agencies. And agencies, they're trying to rein them in. They're frankly trying to clip their wings and tell Congress, you have to do a better job of legislating with specificity, and agencies, you need to watch your back because the Supreme Court is going to be skeptical of your actions.
Finally, what will agency scientists and policy experts need to consider when they're establishing new regulations in the future? Barring any action by Congress, what can agency officials do?
I think that this is going to be very difficult for agencies. I mean, they were already preparing in some ways, again, for this set of decisions. And again, these two are not the only ones that the Supreme Court has come out with in the last few years that have made it more difficult for agencies. But agencies are going to have to think twice about how much detail, what sorts of regulatory tasks they are going to undertake because they are so costly. Each one is going to be subject to, again, this long, lengthy notice and comment process. They have to sort of fastidiously document their administrative record, their scientific grounding, but they also have to look to clues in the statutory record to make sure that they have the authority to exercise their authority in the way that they are trying to. And all of this is no guarantee that they're not going to be sued or that the federal court isn't going to turn back their rulemaking. So I think agencies are probably going to do less rulemaking in the future, which is going to leave industry with a lot less certainty. And when they do implement rules, they can expect to face challenges. So some of the resources to just sort of running their programs are going to have to be devoted in some ways to sort of defending and going through this rulemaking process and then defending them in litigation. And then there's this possibility that these rules will never see the light of day. So I think agencies might do more in some regulatory guidance documents like manuals or policy statements that are not binding, again, provide less certainty and are not particularly given a whole lot of deference either. So I think agencies are in a tough spot. And so a lot of it is going to fall to Congress to try to give agencies the explicit authority to do what the agency is trying to do. Otherwise, the agency has a long and difficult road ahead of it.
Thank you, Professor Fuse Brown.